Hello. We now like to talk about how human rights and human rights principles fare during the time when a nation feels like it's in crisis. And that crisis has come to the United States and to some extent to the United Kingdom because of terrorist attacks that have occurred early in this century and particularly for the UK even before that. Our objectives today are to, first of all, understand how fragile human rights principles are during times of crisis and when people feel conflict and feel that they have to defend themselves. We need to understand a little bit about the objectives of terror attacks. And those objectives, I think we'll decide, include the idea of disrupting societies and causing them to react in ways that may not be healthy for the society that's attacked. We ought to really give a lot of thought to how two nations, the United States and Britain, who are both renowned for their records in human rights, have responded to terror. And we need to review the international obligations. What promises have we made in treaties that have some impact on what kinds of responses we can have to these acts of terror? So we see that the United States and the UK have both been attacked. The attack that most Americans think about was an attack on 9/11 of 2001, attack on targets in Washington and New York, and before that, attacks on United States embassies. The United Kingdom was attacked on July 7th, 2005, and there are many other attacks, terrorist attacks, before that and since, including many acts by the Irish Republican Army, which we'll refer to as we go through this analysis. As we look at our responses to these attacks, we really need to think about what kinds of promises we made, what kind of principles have we endorsed, and that we must live up to as we begin to frame our response to terror. And of international treaties, particularly important are the International Convention on Civil and Political Rights. We'll look at that. We'll look at the Convention Against Torture. We need to look again at the Geneva Convention, in particular at Common Article 3 of the Geneva Convention. And for the UK and for the US, when it is dealing with European countries, we need to look at the European Convention of Human Rights. One of the things that will occur to almost anybody as they're beginning to think about how to deal with a response and how to frame your response within context of these principles is that issue we've discussed before when we looked at the European Convention of Human Rights, and that is derogation. After you've entered into a treaty, how do you set the treaty aside for certain purposes? And the fundamental question we have to ask ourselves there, is this a time of war or an emergency that affects or threatens the life of a nation? Those principles of derogation, which apply generally, are spelled out in the International Covenant on Civil and Political Rights. And it tells us that there's no derogation from certain of the human rights that are guaranteed in the convention. There's a right to life. You do not torture. Do not engage in inhumane treatment. You don't condone slavery or forced labor. You're not guilty of discrimination. So there are principles that cannot be set aside even in time of war, or at times when the life of the country is threatened, if indeed that condition exists. So let's look now, first of all, look again at Article 10 of the International Covenant on Civil and Political Rights. All persons derived of their liberty shall be treated with humanity and with respect for the inherent dignity of the human person. As we go through this lecture, we're going to take a look at some of the pictures of activities conducted particularly by United States troops and officials, condoned by officials. And as we look at those pictures, I want you to remember the promises that we made in the International Covenant on Civil and Political Rights. We promised that all persons deprived of their liberty shall be treated with humanity. And as you look at those pictures, I hope that you will make an assessment about whether you believe that that promise has been fulfilled. The International Covenant on Civil and Political Rights in Article 7 very specifically relates to torture and to cruel, inhumane, or degrading treatment or punishment. And again, keep these in mind when later in this lecture we look at the pictures coming out of detention facilities. The Convention Against Torture says not only shall you not torture, and you shall not engage in any inhumane treatment, it also requires all parties to that convention to take effective measures to prevent acts of torture, and it indicates that even if there's an order from a superior officer, that does not justify torture. And Article 12 of the Convention Against Torture tells us that each state shall ensure that its authorities proceed to a prompt investigation whenever there's reasonable ground to believe that an act of torture has been committed in any territory under its jurisdiction. And again, let's go back and look at Common Article 3, which we addressed earlier in this class. We have made a commitment in Common Article 3 that in any case of an armed conflict, not of an international character, occurring in the territory of the high contracting parties. Now, in the territory means territory not only within its national boundaries, but territory that it controls. And so that Geneva Convention tells us that in all circumstances we shall treat persons humanely. And there will not be outrages on personal dignity, or in particular any submission to humiliating or degrading treatment. These are promises that we've made to the world by entering into these treaties. Now, as we look at the United States responses to the 9/11 crisis, we're going to see, and it's interesting to have a case study to look at all three branches of our federal government, Congress, the executive, and judicial. And we'll take a very look, and I must say superficial view, at the responses of each of these. First of all, the beginning response to the attack on September 11th of 2001 was an adoption by Congress a week later of the authorization for use of military force. And if you read this authorization, it's not a declaration of war. It's authority for the president to use all necessary and appropriate force against those nations, organizations, or persons who have planned, authorized, committed, or aided terrorist attacks that occurred on September 11th. Shortly after that, Congress then passes what's called the Patriot Act. Be pretty careful when you hear that Congress is using a term like Patriot Act, because you may find that some rather sinister things afloat behind that really rather magnificent title. Here, the Patriot Act allows federal officials to intercept communications if doing so prevents terrorism. And that broad authority to intercept communications is not checked very much, has not resulted in very many actual prosecutions or criminal referrals. And although it's been reauthorized, that act remains quite controversial. Congress in 2003 passed, again, something with a wonderful title, Protect America Act of 2003, and it removed the warrant requirement for government surveillance of foreign intelligence targets, reasonably believed to be outside the United States. As we'll see, this can lead to a great deal of mischief by officials of the United States. We had already a Foreign Intelligence Surveillance Act, which was enacted in 1978. There were amendments to that act in 2008, and it reauthorized many of the provisions of the 1978 Act, and particularly allowed for the Foreign Intelligence Surveillance Act court to look at these applications to a secret court operating in secret with no notice to anyone but the decisions of the court, allowing the executive branch to continue to invade the privacy of U.S. citizens and those outside the country. The executive branch now uses the authorization for use of military force to conduct, first of all, a war in Afghanistan. The basis for the war in Afghanistan was that there were training operations and planning operations being conducted by people who were actually cited in Afghanistan. So there was at least a thin argument for the invasion of Afghanistan. It was also used to support a war in Iraq. The rationale there, as we see in a moment, was even less robust. And the executive now uses this authorization for use of military force in the memoranda, which begin to develop the principles for our treatment of those people who are detained, either through capture on the field of battle or detained through other processes. The war in Afghanistan actually began in October of 2001. It was called the Operation Enduring Freedom, and it began with the United Kingdom joining in, later joined by Russia, France, Australia, Canada, Poland, Germany, and others. Critical to this were forces already on the ground that were fighting against the Taliban government in Afghanistan, called the Northern Alliance. And it was largely through the forces of the Northern Alliance and through American air power that the Taliban government was dislodged. The war in Iraq, again, started by the United States, the United Kingdom, Australia, and Poland. Other countries later joined. This was the war in Iraq to take away the potential that Iraq would use its weapons of mass destruction, weapons that never existed, that the United States, after the invasion, spent many weeks seeking to locate and reveal to the world an embarrassing episode diplomatically for the United States, because the American Secretary of State, Colin Powell, went before the United Nations to explain all the evidence for this war engaged in Iraq. That evidence was never found. The weapons never existed, and it was a bogus reason for conducting that war. These conflicts now start producing detainees. In Afghanistan, there was an active battle. People were taken custody on the field of battle. There are also a number of people who were turned over to the United States because the United States offered a large bounty for the capture of anyone who was involved in activities adverse to the United States. It's not surprising that quite a number of the people who were turned over to the United States and made detainees, many of them shipped off ultimately to Guantanamo Bay. There is to this day no evidence that they ever did anything wrong. They were taken into custody, turned over to the United States, and because the United States was offering a large price for them being turned over. Pretty easy thing for somebody in Afghanistan who wanted to settle scores to take custody of somebody who was an enemy, turn them over to the United States, and to collect the money for them.
I want to say something else. I have put this program in place for a reason, and that is to better protect the American people. And when we find somebody who may have information regarding a potential attack on America, you bet we're going to detain them. And you bet we're going to question them. This government does not torture people. You know, we stick to U.S. law and our international obligations. Thirdly, there are highly trained professionals questioning these extremists and terrorists. In other words, we got professionals who are trained in this kind of work. The American people expect their government to take action to protect them from further attack. And that's exactly what this government is doing, and that's exactly what we'll continue to do.
You see these prisons operated by the United States and Great Britain, and you see these other sites. Even though there's Guantanamo Bay established, the United States got involved with European countries, taking detainees to those countries. Considerable evidence that they were taken there because they could be now held far away from any jurisdiction that would grant habeas corpus or give other relief, and far away from any supervision that would be appropriate. As we'll see, this whole process is simply contrary to international human rights law. We made promises in the International Convention on Civil and Political Rights that no one would be subjected to torture or to cruel, inhumane, or degrading treatment or punishment. We've just seen pictures which show that these words were not honored by U.S. conduct in its treatment of detainees. We made promises in the Convention Against Torture. We promised that we would not allow conduct by any officials, even following orders of superiors. The United States also has a law prohibiting torture, and it's drawn in a fairly narrow way. It says that whosoever outside the United States commits or attempts to commit torture shall be fined under the title or imprisoned. Now, so there's a federal statute that says that there will be punishment for anyone who's involved in acts of torture outside the United States. We've just seen pictures of such activity. The road now to violation of these principles is a road, first of all, beginning in the White House, particularly with the office of the Vice President. It was a road that was accepted by the Department of Defense and the Department of Justice. The Department of State, with Colin Powell as Secretary of State, did not agree with the activities or with the statements being made by the White House, the Department of Defense, or the Department of Justice. In the Department of Defense, we have Donald Rumsfeld. And Donald Rumsfeld issued several memoranda. One in January of 2002, that the United States has determined that Al-Qaeda and the Taliban, under the control of the Department of Defense, that is the detainees, are not entitled to prisoner of war status under the Geneva Conventions of 1949. He puts aside the Geneva Conventions. He puts aside Common Article 3, which says that we will treat people in a humane way. He doesn't mention the International Convention on Civil and Political Rights and doesn't mention the Convention Against Torture. He says that we will treat people humanely and to the extent appropriate and consistent with military necessity in a manner consistent with the Geneva Conventions. But the Geneva Conventions, he says, do not apply. Now, at the time that the Department of Defense Secretary Rumsfeld is putting forward these ideas, Colin Powell, Secretary of State, is pushing back. He and his general counsel, called the legal advisor to the Department of State, are saying to the federal government, look, even in Korea, where our troops who were taken prisoner of war were not treated humanely, we acted to treat people in a humane way, and we should continue to do that. It's an act of principle, the United States, to behave itself in a way that's consistent with human rights principles. And the Department of State advised against the action. The Department of State would not allow military necessity to displace the Geneva Conventions of 1949. The Department of Justice issued a series of memoranda. They're now available. You can get them online by going to Google, and you can find these series of memos. As you read these memos, I believe you're going to see them in the light of some lawyer for the mafia advising people what arguments they can make to keep from being prosecuted by this federal law which prohibits use of torture. And so these memoranda, one in August of 2002, analyzes torture by redefining torture, saying that torture must be equivalent in intensity to the pain accompanying serious physical injury, such as organ failure. Well, where did this come from? It's pulled out of thin air. It simply doesn't exist. As you read this memo and other memos issued by the Department of Justice, you just have got to feel grief that the lawyering is so bad and the result being proposed to the executive branch is so inconsistent with the promises that have been made through these international treaties. One of the things that the Department of Justice memoranda says is it analyzes the case of Ireland versus United Kingdom. You may remember this is a case decided by the European Court of Human Rights, and it related to British action in treating detainees. The European Court of Human Rights decided that certain actions, these 5 techniques used by the British police forces in its interrogation of detainees in Northern Ireland were not torture. The court did decide that this was inhumane treatment. But remember, there's the federal statute providing a criminal penalty for torture. And what this memo is doing is trying to argue its way out of torture and arguing its way out of criminal prosecution of military authorities and U.S. officials who are condoning torture. And so the European Court in the Ireland versus UK case found no torture where detainees were beaten and forced to stand spread eagle against a wall, forced to stand against a wall by kicked on the insides of their legs. One detainee was beaten so much they had a perforated eardrum. But the European Court said this was inhumane treatment, but not torture. Curiously, the Department of Justice did not look very deeply into other cases that have dealt with inhumane treatment. And the Department of Justice seems to ignore the fact that our promises were that we would not torture and that we would not commit acts that were inhumane to detainees. Now, George Bush speaks on legality.
You can't expect me and people in this government to do what we need to do to protect you and your family if we don't have the tools that we think are necessary to do so.
And you said within the law, and yet you admitted that there were these CIA secret facilities. Okay.
So what? Why is that not within the law?
The head of Amnesty International says secret sites are against international law.
Well, we just disagree with him.
Were you made personally aware of all of the techniques that were used, for example, against the Khalid Sheikh Mohammed, and did you approve all of those techniques?
I told our people get information without torture, but one of the best source, according to those who are on the front lines of protecting the American people, is when we pick up somebody off of a battlefield, that we interrogate them within the law.
I don't want to let this within the law issue slip, though. I mean, if in fact there was waterboarding used with Khalid Sheikh Mohammed, and for the viewers, that's basically you strap someone to a board and you make them feel as if they're going to drown. You put them underwater. If that was legal and within the law, why couldn't you do it at Guantanamo? Why'd you have to go to a secret location around the world?
I'm not going to talk about techniques.
At some point, Mr. President, if techniques, these alternative techniques are used, I'm not going to ask you to specifically say about them, but if they are used, are you at all concerned that at some point, even if you get results, there's a blurring the lines between ourselves and the people we're trying to protect us against?
And whatever we have done is legal. That's what I'm saying. It's in the law. We had lawyers look at it and say, Mr. President, this is lawful. That's all I can tell you.
As you look at the rationale given by President Bush, you realize that that rationale was one that was backed up by legal memoranda written by the Department of Justice, Department of Defense, and by the President's own counsel. Now we come from the executive to the judiciary. Here we have a series of decisions, of court decisions, and we need to integrate these court decisions with a congressional response. The Rasul versus Bush decision in 2004 said that the court had jurisdiction over Guantanamo and detainees had a right to an impartial tribunal to challenge their detention. And they had the right to use habeas. Remember that Guantanamo was selected in part because the legal team advising President Bush thought that if you put people down in Cuba, the federal courts won't be able to reach to Cuba, and habeas corpus will not be available to them. We'll put them beyond the reach of law. Well, the Supreme Court decides originally in 2004 that the court had jurisdiction over the American facilities in Guantanamo Bay. And there was a right of habeas corpus. In Hamdi versus Rumsfeld, the U.S. citizens who were detained as suspected enemy combatants had the right to habeas corpus challenge of their decisions. Now, following the Hamdi decision, Congress passes what it calls the Detainee Treatment Act of 2005, and it purports to restrict habeas filings. In the case of Hamdi versus Rumsfeld in 2006, the court dealt with this. And it said that Congress lacked the authority to create these military tribunals, lacked the authority to get around habeas. And so in response to this, Congress passes the Military Commissions Act. And it now authorizes military tribunals, leading us to the 2008 case of Prohibiting versus Bush. Guantanamo detainees are entitled to the protection of the U.S. Constitution. And Justice Kennedy, writing, said the laws and Constitution were designed to survive and remain in force even in extraordinary times. And so the Congressional attempt to cut back on habeas really was rejected by the court, which said that there should be a remedy. Now, has there been torture? Has there been inhumane treatment? We have several different reports to look at in response to that question. In 2008, the Senate Armed Forces released a part of a report in which it found the abuse of detainees cannot simply be attributed to the action of a few bad apples. Senior officials in the United States solicited information on how to use aggressive techniques, refine the law to create the appearance of illegality, and authorize the use of these techniques against detainees. Now, remember that we have the Convention Against Torture, which requires us, where these facts are found, where there is action which goes beyond our commitments not to torture, there's a duty to conduct an investigation. Some investigations have been done, but if we look at that history, we're going to find that it's not a very substantial investigation, and a number of the people very directly involved have never been investigated, prosecuted, or sanctioned in any form whatsoever. This Senate Armed Forces Committee report is not the only report. The International Committee of the Red Cross report becomes, a part of it becomes public in 2009. And they look at what the Red Cross says. For certain methods, notable suffocation by water, with health personnel directly participating in the infliction of this torture. Detainees were shackled in stressed standing position for prolonged periods in their cells, were monitored by health personnel, who in some instances recommended stopping the method of ill treatment. So the Senate Armed Forces Committee, the Red Cross reports that we now have been involved in significant abuses, including torture. There's also a report by a private group, the Constitutional Project's Task Force on Detainee Treatment. The leaders of this task force were former congressmen, both Republican and Democrat, and a number of leading judges and scholars. The former director of the FBI was a member of that task force. It made 24 findings. It found that U.S. forces, in many instances, used interrogation techniques that constituted torture. So this bipartisan group concluded that there was torture. It concluded that top officials allowed and contributed to the improper interrogation techniques. Now, I served on this task force and had a chance to look at the evidence that was brought before the task force. And I must say that it's so substantial that there really cannot be much doubt about the fact that the United States broke its promises when it entered into the Convention on Civil and Political Rights and when it entered into the Convention against Torture. There has been some litigation over the treatment of detainees. Been one instance where a U.S. defense contractor has paid a substantial sum in settlement. There have been, but most of the damage suits brought in the United States have been dismissed, with the United States asserting sovereign immunity. In British cases, there have been a different result, and there have been several British cases in which have led to compensation, and some of that has been through settlements. The UN, at one point in 2013, UN Committee Against Torture urged that the United Kingdom make further inquiry into the allegations of torture and ill treatment. And so this is an instance where a UN treaty body now reacts with a nation and urges them to take action beyond that they've taken. I now want to touch very briefly on the use of drones. And ask, first of all, the question, what human rights principles are implicated by the use of armed drones away from the battlefield? First of all, Article 6 of the International Convention of Civil and Political Rights says that every human being has the inherent right to life. This right shall be protected by law, and no one shall be arbitrarily deprived of his life. And later section says the death penalty can be carried out only pursuant to a final judgment rendered by a competent court. So there must be a judicial process before there be a sentence of death. And the European Convention, very similar. Everyone's right to life shall be protected by law, and no one should be deprived of their life intentionally except by a sentence of a court. So there has to be a judicial proceeding to have a taking of a life. Now, are lives taken in the process of these drone strikes? The answer by the UN Commission of Human Rights, which appointed a special rapporteur to look at the strikes in Yemen, found that there was arbitrary killing and a clear case of extrajudicial killing. So extrajudicial killing, that is an assassination, even by a drone, off the battlefield, is a violation of international human rights. And this is an issue that that international law is just beginning to deal with, and will have to continue to deal with the proliferation of drones and the use of drones in places where the nations have not authorized their use. There are questions of sovereignty, there are questions of human rights, and there are strong questions about how the use of drones can be rationalized with human rights principles.
U.S. targeting practices, including lethal operations conducted with the use of unmanned aerial vehicles, comply with all applicable law, including the laws of war. Targeting particular individuals serves to narrow the focus and to avoid broader harm to civilians and civilian objects. But a state that is engaged in armed conflict is not required to provide targets with legal process before the state may use lethal force. And there is no prohibition under the laws of war on the use of technologically advanced weapons systems in armed conflict. And thus, in this ongoing armed conflict, the U.S. has the authority under international law to use force, including lethal force, to defend itself.
Now, Harold Coe, who is a wonderful legal scholar, former dean of Yale Law School, former high-level administration official in an earlier time. He was the Human Rights Assistant Secretary of State in the Department of Defense, very knowledgeable, a very great critic of the practices of the Bush administration, but now is an apologist for the use of drones. And there is a Department of Justice white paper, and we've not seen the whole paper, but we know that it advances a three-part test for the use of drones. First of all, a high-level American intelligence official must determine that the individual poses an imminent threat, that capture is not feasible, and that the strike is conducted according to the laws of war governing the use of force. Now, you're using force of a type that's going to kill people who are struck by these missiles. You're involved in sometimes in what essentially is an assassination. You're involved sometimes in assassinations of civilians who are not on a field of battle and indeed are located on the territory of nations who are not at war with the United States and have not given permission for the use of the drones in this type of activity. So we're dealing with drones with a very complex international human rights law problem, one that we're still trying to sort out. As of 2013, that sorting out still continues. I hope in this process, this lecture, that we've been able to show the conflict between what principles of international human rights law govern conduct following some incident, even a serious terrorist incident, and the activities of governments. And it makes me sad to say that for my own country, I have to see a rather consistent pattern of breaking promises, the promises made to other nations when we enter into these treaties. We have violated, in my judgment, the International Convention on Civil and Political Rights, and we have violated the Convention Against Torture. We've been engaged in activity that a number of people have said, I think appropriately, is simply un-American. The British government, likewise, has engaged in activity which is un-British. And for those of us who are citizens of these countries, we need to reflect on whether we value our security so much or so frightened of something that might happen to us in the future that we would condone this kind of activity. In the United States, we frequently like to say we're the land of the free and the home of the brave. But as I look at this sorry history of our activity since 9/11 of 2001, I conclude that we're not a land that respects freedom, that respects the rule of law, protecting freedom, and we're not the home of the brave, because we've now allowed ourselves to be driven into a course of action which is supported by our fear of future activities and has allowed us to let people who urge that we go to the dark side to take action which is inconsistent with our fundamental principles.